that doesn't end the inquiry, and I think it's been oversimplified. Professor Carter alluded to this. No, the standard is whether it was reasonable that he feared imminent death or great bodily harm. Now, the defense has an argument that they have advanced that says that's it, but that's certainly not the only argument. It's not the law. It's not the instruction. The instruction is, was his action reasonable? And given what we now know about the defendant's version and how much credibility he has, the defendant's attitude and history, and what he felt and thought, and the actual extent of the injuries, which again, the law, it is true that the law says you don't actually have to have injuries, but why exaggerate them? Why make them to something that they really aren't? So the question is whether he was reasonable in using that level of force, particularly if you believe the defense's theory that, well, he knew the police were going to be right there. So the one final inconsistency I'll point out as to whether or not this was self-defense is as it relates to the defendant's account to his best friend. When you think about it, the defendant swore that he was attempting to scoot or move or somehow get off the sidewalk at the time that he claims Trayvon Martin was above him with his knees to the defendant's armpits. And yet at that same time, according to the defendant, Trayvon Martin noticed the defendant's firearm and went for it. And the defendant, nonetheless, was able to grab it, pull it out, and as he demonstrated, fire it into his heart. I want to say something about the Jenkins case because Mr. O'Mara characterized that as, quote, one of the most instructive cases, and, quote, the facts are close. Here are the facts. Witnesses described Mr. Cerezo, that's the victim, as furious and a wild man. Mr. Jenkins testified that Mr. Cerezo was acting like a lunatic. Mr. Cerezo claimed that he was a gang member and that he would come back to the mobile home park with 20 guns and silencers and kill everybody. One of the witnesses testified he heard Mr. Cerezo yelling, "I'm going to kill you, you're a dead man." Another witness heard Mr. Cerezo threaten to burn down Mr. Jenkins' trailer. Mr. Cerezo claimed that he had a Glock with which he was going to cap Mr. Jenkins. Mr. Cerezo then clenched his fist and charged at Mr. Jenkins again. Those facts are not close. One of the final cases I cited to Your Honor is the case of Hoffman versus State, and I think I even saw this in the defendant's packet as well. The court cited the familiar, and this is the 5th District Court of Appeal. For judgment of acquittal must be denied unless there is no legally sufficient evidence on which a trier of fact could base a verdict of guilt. In considering the motion, all facts introduced in evidence are considered admitted, and all inferences and conclusions must be drawn in favor of the state. Then we get to Head Note 4. A jury question is presented when the evidence is reasonably susceptible of two views, either that the defendant's action in shooting was justifiable self-defense, or that such action evinced a depraved mind without proper regard for the life of victim. The evidence adduced at trial clearly allows for a difference of opinion between reasonable people as to whether the shooting was in self-defense, and therefore the court said that the motion denied. So I go back to the fact that one first has to consider whether or not the state has satisfied the standard at this stage of trial as it relates to the defendant's state of mind. We believe we have, both through the direct and circumstantial evidence, even if the circumstantial evidence were considered alone. Secondly, assuming that, the only hypothesis of innocence advanced or suggested is that the defendant acted with justifiable use of deadly force. That is certainly open to question, as is everything pretty much that the defendant himself has said. So the state believes the motion should be denied. I will close by saying that even if the court felt compelled to grant at this stage a motion as to second-degree murder, there remains the necessarily lesser included offense of manslaughter, as to which there is no requirement of showing ill will or anything like that. And therefore, the state believes that even if, and we're not saying you should because I think I've made the point, but even if, at a minimum, proceed forward on that charge. Thank you, Your Honor.
Yes, I just want to make sure that my rendition of the Jenkins facts are properly presented to the court. I did not suggest that Trayvon Martin said he was a gang member, did not say that he suggested he had a Glock, did not say he suggested he was going to cap Mr. Jenkins. And actually, these facts are more serious than what that victim did in the Jenkins case. Lisa, the victim in Jenkins, hit him one time and threatened a bunch. In this case, we know that the facts are so much more serious than that. Because in this case, they start out similar. Trayvon Martin sucker punched my client, and there's nothing to contradict that. And we have the injuries to suggest nothing else but what my client said right after the fact, before he knew there was an eyewitness to or not to it. But what Cerveza didn't do in the Jenkins case that Trayvon Martin did in this case was continue the attack, and continue the attack, and continue the attack. Because Jenkins didn't allow that to happen. Jenkins stabbed him to death with a second blow. My client waited an additional 40 seconds. So the suggestion that the Jenkins facts are inconsequential, actually that they're more severe than the Zimmerman facts, is just an ignorance of the fact, or at least its application to the law. Similarly, the state seems to ignore the reality of the Leisure case, because they suggested and actually spent a good part of their argument talking to you about the Leisure case and its applicability. Sometimes bad facts make bad law, but let's look at the Leisure case for a minute. You may remember this case. It wasn't that long ago. It's a case where Miss Leisure stated to 911 3 completely separate events of what happened. She said to the 911 operator, if I could have just a moment, because you know the case, well, just so that we're clear, in that case, Ms. Leisure came up with 3 completely different stories. He shot himself, I shot him in self-defense, you're going off accidentally. If those are the type of inconsistencies that the state wants you to focus on, please do. You probably should. But the facts in the Zimmerman case are much, much different. Because what the state has sort of done is ignore the facts that they want to ignore. Because what they told you is here's their direct evidence. What he said on the non-emergency call. Not the way John Guy said it. Not the way Bernie Deloranda says those are expletives. But they want you to take from that phone call the beginnings of ill will, spite, and hatred. Because unfortunately, Mr. Manti decided not to address ill will, spite, and hatred virtually at all in his argument to you. In an offhand way at the end, he said, well, if you're going to get rid of second degree, at least don't get rid of manslaughter. But where is the state's case that even in the light most favorable to them, looking at all of the evidence, not just that which they wish to focus you on, but all of the evidence, how they get to ill will, spite, and hatred? That he made up stories? Well, you have an opportunity to review the evidence. You sat through here with all of it, just like we did, and see whether or not those stories were made up. Whether or not, as Serino stated, and as Singleton stated, they were insignificant changes. Matter of fact, they were changes or developments that they would expect the more time they questioned somebody. That's why John Good's half of a page statement went to a 4-page statement, went to an 8-page statement, went to a 50-page deposition. You know it as well as I do, and you know what? As well as the state does. That's why they can't come here and say to you, he said he shot him in self-defense, he said the gun went off by itself. There is none of that. Those inconsistencies are merely what happens when you tell a story 2 or 3 or 4 times to different officers after you've been through 2 traumatic events. Getting the hell beat out of you by some, I'm sorry, Your Honor, getting beat up by somebody the way he did, and then the trauma of having to shoot somebody to defend your life. Now, we can minimize the trauma that George Zimmerman has gone through, but we really can't when we're going to compare what happened in his statements, because if you want to look at what is in the light most favorable to the state and say to them, you know what, I'm going to rule that one in your favor, as we've said many times in this room, you can't do it in a vacuum. You can't look at it and say, this little fact I'll put in your favor, goes on your side. This little fact I put in your favor. You have to look at the totality of the circumstances and see whether or not the direct evidence that they say they have convinces you. One piece of direct evidence that they've shown to you, and I'm presuming that they've shown you all of their direct evidence already, and that Mr. Manti just took an opportunity to present to you all of that direct evidence which supports ill will, hatred, spite. And they said, we have Nofke. We have my client dared to suggest that he was on drugs. It is not properly before this court as to the veracity of my client's understanding as to how Mr. Martin may have been acting. But you can certainly consider everything that you've heard with the way he said he was acting. So that's a second piece of direct evidence that my client thought he was on drugs. And then he said he wouldn't have done anything differently. He didn't do anything wrong. He contends that to the police officers in every statement he gave. He didn't do anything wrong. He contended that to Sean Hannity. I wouldn't have changed anything. Now, does that mean, maybe that's the callous indifference to human life and ill will. I shot him and I don't care. It's not what was said. It's not what was intended. And that's an absurd suggestion that when he said, I didn't do anything wrong, I wouldn't change anything with what I did, that suggests that he, like any one of us, wouldn't have decided not to wake up that day or get in the car that afternoon or go to Target that night. That type of an absurdity suggestion by the state should not be considered as valid argument to you as to why this court should not grant a judgment of acquittal. And you have said, I would opine, and I know that I have said, whenever a tragedy happens, that it's God's plan. Every time I've lost a loved one, that past has either come through my lips or through my brain, that we have to think to something beyond ourselves to decide why something crazy, terrible, horrible happens. If you actually believe that that is evidence of ill will, spite, and hatred, if they're actually suggesting, because after all, if we're going to compound inference upon inference, they got to take their pick. Either he is a wonderfully creative and perfect murderer who can come up with the best of plans in a split second, but then 6 weeks later, whatever he says something that is just from his heart, and now that's ill will and hatred. Give him credit one way or the other. Or just suggest that you know what he was, and you know what he is? It's just a human being. Yeah, he was going to school. He had decent grades, a book he may have read or not. The reality is he went through a traumatic time, and he's trying to deal with it just like the Martin family is trying to deal with it. They have more of a loss. My client carries his in life. They carry theirs through death. But the reality is you have to look at the direct evidence that the state presents to you to say, have they proven their case to the extent that they should get the benefit of the JOA standard? So, direct evidence, Rachel Gentile, get off. Yeah, if that's at all credible, if that was at all credible, the way it was presented by Mr. Crump, the way it was presented by her, and the way it was presented, if that's the only word that I'll use rather than created, after the inquiry with Miss Sabrina Fulton at the House and then with Mr. Bernie Delarianda at the House, so be it. Then they say that Mora and Sudaika suggest pursuit. You'll remember the testimony, I guess,